All rise. This court is now in session. Be seated.
Good afternoon. Just very briefly, I think some of you may already know, Judge Susano, former chief judge of this court on the court for 24 years, passed away this weekend. So he is missed by the court and by us as well. Call the first case, please.
Jefferson Howell et al. Versus Chattanooga Hamilton County Hospital et al.
Please court, I'm Marvin Berke from Chattanooga, and I represent the plaintiff in this case. It is a healthcare liability action against Erlanger Hospital, which is a city-county hospital. In this particular case, the plaintiff was injured when a grinder, which he was using, electric grinder, broke and the blade went into his foot, and he was taken by ambulance to Erlanger Hospital. He was treated there by a resident physician in the emergency room who had graduated medical school about 60 days before this happened, and also a medical student who happened to be working in the emergency. There was supposed to be a physician who was a contract employee of the hospital, whose group had a contract with the hospital. They are supervising, but the plaintiffs say they never saw him. The defendant raised the issue of the fact that there was no employee of the hospital that was found to be at fault, and therefore, or even alleged to be at fault, and therefore, under the Governmental Tort Liability Act, the hospital could not be held liable. They cited a case of Gilreath against Chattanooga Hospital, Erlanger Hospital, which was a decision that came out in 2016, and it was the judge's opinion that that case held that there could be no liability unless the hospital or the governmental agency employees were at fault. However, the trial judge, in granting the summary judgment, did not read, or at least did not use the part of the opinion which is located on page 3 of my brief. And in that opinion, that part of the opinion, it said that the plaintiffs could not rely on direct negligence because, in that case, because of the fact they didn't allege it. In this case, it was alleged. And it said that, and I quote, "The GTLA has been interpreted to permit the filing of a direct negligence claim against a governmental entity." And that's what the issue is in this case. They cited Limbaugh against Coffee Medical Center, 59 Southwest 3rd, 73. And also Pendleton against Metro Government of Nashville and Davidson County. They also cited in that case for the proposition that the hospital could be liable when the non-employee is responsible. Tennessee Code annotated 29-26-115A, and they said that Tennessee law clearly recognizes that hospitals owe a duty of reasonable care to their patients and may be directly liable to patients independent of any liability based on the hospital's employees or agents. Now, Erlanger says that they cannot employ emergency room physicians, and so they operate under a contract, or their group operates under a contract with the hospital, and their group assigns doctors to work the emergency room. There are various statutes of the state of Tennessee that talk about the fact that Erlanger and governmental hospitals are responsible for anything that happens in the emergency room. At least that's the plaintiff's contention.
What statutes? What statutes say that?
Well, TCA 29-20-207 removes the immunity for injury arising out of the provision of emergency services. And that particular act, we think, is one of the reasons that they should be held liable. The defendant has seemed to indicate that if it were a regular hospital, not a governmental entity, that the hospital could be liable in this situation, because there are numerous cases that indicate that when an emergency room physician or someone that is thrust upon the plaintiff where he doesn't pick out the physician himself, then the hospital can be liable. But they say that because the doctor is not an employee of the hospital, then governmental immunity takes over and the hospital can't be held liable. And we say that the Gilreath case, which the judge used in making his decision on summary judgment, specifically says that the hospital can be held liable. And there are licensing standards for hospitals that say that, and they're put out by the State Department of Health, and they're cited in my brief. And those particular standard sections say that all hospitals must treat patients in the emergency room with acceptable standards of practice. Now, it's the contention of the plaintiff in this case that the hospital has a clear obligation to, number one, to provide emergency services, and number two, to provide emergency services which are within an acceptable standard of practice. And therefore, the hospital is liable, and the provisions of the Governmental Tort Liability Act specifically indicate that they are liable. Boren against Weeks, who's cited in our brief, indicates that the hospital can be liable for the acts of independent doctors in the emergency room, and they reversed a summary judgment in that case. Now, that was a non-governmental hospital. So the question in this case is a governmental hospital which should be held to the same standard, and the statute specifically says they can be liable. And also Gilreath indicates that they can be held liable.
Gilreath also was a non-governmental hospital, wasn't it?
No, it was the same hospital.
Same hospital, excuse me, you're right.
It's Erlanger.
What do we do with the, what do you say that, I mean, does the GTLA just not apply here?
No, we say that a hospital, if they have liability, and that's what Gilreath says, is that they can be liable for violation of hospital practices.
In Gilreath, though, were the actors employees of the hospital? They were not independent contractors?
I'm sorry, Your Honor, I didn't understand.
In Gilreath, though, the actors for whom they were alleging Erlanger should be vicariously liable, were they employees of the hospital as opposed to independent contractors?
Well, the decision says that the plaintiffs did not specifically allege in the complaint that they could be liable for non-employees' actions. Okay? And therefore, they didn't get in the question, but they said in the opinion that they could be held liable. And as I say, that particular section of Gilreath is quoted in my brief on page 3. It's our contention that the ruling of the judge, the trial judge, on summary judgment should be reversed, and that this case should proceed to trial. And I'll answer any other questions that the court may have.
I hear that.
Thank you.
Thank you. We'll hear from the appellee.
Thank you, Your Honor. Good afternoon. May it please the court. My name is Josh Powers. I'm from Baker Donaldson firm in Chattanooga. I think it may, and it, when Judge Swiney, when you referenced Judge Susano, the Gilreath decision, obviously, as Your Honor is very familiar with, was written by Judge McClarty, you, and Judge Susano. And I think it helps to put this case in context a little bit of how did we get here. Initially, when the lawsuit was filed, it was a lawsuit against ER doctor, ER group, and Erlanger for somebody who came into the emergency department. The ER group and the ER doctor, they've been dismissed from the case. We understand there's been a resolution there. So then the question is with Erlanger, how did Erlanger, why did we file a motion for summary judgment? Plaintiff had a deadline of January 1 to file their expert disclosures. Plaintiff did not file expert disclosures, and as all three of you all are very well aware, to make out a claim for health care liability, you have to have expert proof. So 2.5 months went by, we waited, and then we filed a motion for summary judgment and attached the affidavit of a nurse who said that Erlanger met the standard of care. That was not disputed by plaintiff's counsel. So then the question is, because the way I read Gilreath, first of all, Gilreath absolutely stands for the proposition that in order for a governmental entity to be liable for a claim of negligence, there has to be an employee of that entity, whether it's Erlanger or whatever governmental entity, and that's right out of Gilreath, because it defines, and Section 205 specifically says that, and then it lists here the 5 things that all must be found under Section 107 of who is a governmental employee. So then the question is the way I read Gilreath is, it allows for a direct negligence claim against Erlanger. So if you think there's 2 ways that Erlanger could be liable, a direct negligence claim or vicarious liability. Vicarious liability, Gilreath completely controls in that situation, because the only actors in this case, if you step back and think, what did plaintiff claim? Jefferson Howell comes into the ED because he's working on a grinder and he's hurt his foot. when we filed our motion for summary judgment, the plaintiff then filed a response and attached the affidavit of one expert, a doctor, Dr. Suzanne Story. Dr. Story said that what should have happened was instead of an x-ray, he should have had a CT or an MRI, and he should have had an orthopedic consult. That is almost exactly what the claim was in Gilreath. Should have had a CT or MRI and should have had a neuroconsult. That was a Cauda-Equina syndrome situation. So Judge Hedrick, frankly, I think was very generous in allowing, because we filed a motion to strike because Dr. Story's affidavit is being late. It was 2.5 months after the expert disclosure deadline. But Judge Hedrick was very generous and allowed that affidavit to stand as plaintiff's expert proof. The only claimed negligence was should have done a CT, should have done an ortho consult. Those are only things that physicians can do. And Erlanger does not employ any physicians in the emergency department. They can't by statute. So then the question is okay, did plaintiff make a direct negligence claim against Erlanger? And they did not in this case. To read, this is direct, because that was one of the things that this court was looking at in Gilreath was, because the court acknowledged from Barks that you can make out a direct negligence claim, but this is what this court said in Gilreath. It says, to the contrary, it says, other than conclusory references to Erlanger's failure to provide care, plaintiffs did not set forth any specific facts to establish that Erlanger acted with less than, below the standard of care. And that's exactly the situation here. There's not one single fact. There's no expert proof whatsoever that Erlanger failed to do something and that it caused harm. There was no expert proof. The only expert proof in the record is the affidavit of Dr. Story, which says the ED doctor should have ordered a CT or MRI and should have ordered an orthopedic consult. So there's absolutely no, and then if you look at the plaintiff's complaint, those are the two allegations that the plaintiff makes in the complaint. So there's no claim of direct negligence against Erlanger pending in this case. So when Judge Hedrick granted the motion for summary judgment, the only potential claim that he had was whether or not Erlanger was or could be vicariously liable. And the proof in the record was 100% clear that every physician who cared for Mr. Howell in the emergency room was not employed by Erlanger. They were employed either by an ED group or the University of Tennessee, which the medical resident was employed by the University of Tennessee. That was Dr. Brittany Walsh.
Did Erlanger contract with the physicians for services in the emergency room?
I'm sorry, Your Honor.
Did Erlanger contract with the physicians for services in the emergency room?
So not with the physicians. So there were two physicians, Dr. Ben Smith and Dr. Brittany Walsh. Erlanger does not contract with Dr. Smith or with Dr. Walsh. Erlanger did have a contract with an ED group to provide those providers.
And were they part of that ED group?
Dr. Smith was, Dr. Walsh was not. She's part of the resident, the physician training program, the resident training program from the University of Tennessee. And Dr. Smith was, Ben Smith, who was her attending physician, was the attending physician who was in the emergency room to supervise and to supervise does not mean standing over the resident watching them do every single thing. It's being available and in the emergency department, because a resident physician is a physician. They've graduated from medical school. So, but I think the issue is there a claim of, because there's only two ways that Erlanger can be liable. Is there a claim of direct negligence or is there vicarious liability? And I think if we just discussed, there's no claim of direct negligence whatsoever. And because the alleged negligent actors are not employees of Erlanger, Gilreath absolutely controls, and Judge Swiney, I think your question earlier to Mr. Berke was appropriate. What about does the GTLA not apply? The GTLA absolutely makes an enormous difference here because, as all three of y'all are well aware, the GTLA is in derogation of the common law. And because it's in derogation of the common law, it must be strictly construed. And when you look at this, the one provision, so first of all, I think there are three provisions to look at. Section 205, 292205, which says immunity from suit for all governmental entities is removed for injury proximately caused by the negligent act or omission of an employee. So the City of Chattanooga Police Department can be liable if one of its officers acts negligently, if he or she is an employee of the police department. Section 107 then describes who is an employee of a governmental entity. And there are five. What's important about 107 is it says a person who is not elected or appointed shall not be considered an employee unless the court specifically finds that all of the following elements exist. And there are five of them. The governmental entity selected and engaged that person. The governmental entity is liable for payment of compensation. So if we apply that to this case, did Erlanger select and engage Ben Smith? No, there's no proof in the record of that, or with Brittany Walsh. Is Erlanger liable for the payment of Ben Smith's compensation? Absolutely not, and there's no proof in the record of that. Does Dr. Smith receive the same benefits as Erlanger employees? No proof whatsoever in the record. Is Dr. Smith under the control and direction of Erlanger? Absolutely no proof of that. And is Dr. Smith entitled to the same job system and rules? So it's not the fact that in order to be an employee of a governmental entity, the plaintiff has to submit proof that Dr. Smith and Brittany Walsh met all five of those. There's no proof in the record of any of them. So then you go back to 205. So immunity from suit is only removed for the negligent act causing personal injury of an employee. So since neither Dr. Smith nor Dr. Walsh meet the definition of employee by having all five of those factors, Erlanger is not liable. Now, I would, this provision 2920-207, this is one of those provisions, and sometimes I think in reading, I've had occasion to do work for Erlanger for quite a number of years, and I've had occasion to try to read and understand the GTLA, and it is thickly written and can take quite a bit of focused reading to try to parse out the meaning. And I think this provision that Mr. Berke referred to about emergency services, I think if the court looks at that real closely, this is 2920-207, which we've addressed in our brief. This is a provision that deals with different governmental entities reaching agreement on the provision of emergency services. So, for instance, if we were talking about Chattanooga, for instance, it would be the city of Red Bank reaching an agreement with the city of Chattanooga that, hey, if we need your help to fight a fire, and the city of Chattanooga Fire Department has to come and help us out, or vice versa. That's what this 2920-207, because it applies to contracts of a written mutual aid, automatic response agreement, operational agreement, or contracts under 4 separate statutes. And if the court, and we've outlined this in our brief, but if you look at each one of these 4 statutes, these deal with contracts and agreements between differing types of governmental entities, like a county and a city, 2 counties, a county and a governmental agency. So 2920-207 does not say that governmental hospitals are no longer immune and that it is somehow overturning Gilreath, not in any way, shape, or form. So again, what we would ask the court to do in this case is to affirm Judge Hedrick's motion for summary judgment, because there was no claim. You've not heard any specific claim or read any specific claim in the brief by the appellant of what did Erlanger do that it was supposed to do, other than 2 doctors in the emergency department didn't order the right diagnostic test or an orthopedic consult. Because if you, like what Barks talks about is where it allows a direct negligence claim is where Erlanger's policies such, where there's something wrong with their policies or those policies weren't properly communicated to the ED staff. You've heard none of that here. So there's absolutely no claim of direct negligence. And because neither Dr. Walsh or Dr. Smith were employees of Erlanger, there can be but no vicarious liability. So if you look at the facts of Gilreath and you look at the facts of Howell, they are almost identical. They are almost squarely on top of each other, if not identical. So we would just ask the court to affirm Judge Hedrick's ruling in the trial court, and appreciate your hearing me this afternoon. Thank you.
Mr. Berke, before you get too far into your response, I wanted to ask you a question about your interpretation of Gilreath. As I understand your argument, and you said it's on page 3 of your brief, that language of Gilreath is kind of what you are relying on. And that language says that the GTLA has been interpreted to permit the filing of a direct negligence claim against a governmental entity. It cites Limbaugh and Pendleton. And then it says, Tennessee law clearly recognizes that hospitals owe a duty of reasonable care to their patients and may be directly liable to patients independent of any liability on the hospital's employees or agents. So my question is, what part of that language supports your argument that the hospital can be vicariously liable for independent contractors?
Well, the claim is that the hospital can be liable because the hospital didn't furnish the services, the emergency services they were supposed to offer to the plaintiff. Now,
so you're saying it's a direct liability claim?
Yes.
Not an independent, not a vicariously liable?
That's correct. And the plaintiff came in, if the plaintiff had a choice of doctors, do you think the plaintiff would have picked an unlicensed former medical student that had been out of medical school approximately 2 months and a medical student to work on him? Erlanger assigned those, or the doctor or whoever's in control assigned those 2 people to work on the plaintiff, and they negligently did what they were supposed to do. And they were not.
Is there any proof in the record that Erlanger assigned those 2 people?
Well,
as opposed to
Erlanger,
Tennessee, let me finish, and their employer?
Well, either Erlanger or someone there in the emergency room, either the physician in charge or someone else, assigned those 2 people to work on Mr. Howell when he came into the emergency room.
Was there any allegation that was negligent?
Is there any allegation of negligence?
No, any allegation that the assignment of those 2 doctors or those 2 individuals were negligent, that was negligence?
Well, the fact that they were assigned and the fact that neither one of them had a license to practice medicine, the Erlanger allowed people...
Is there anything showing that was negligent, that didn't comply with the standard of care for hospitals?
Well, we think that the proof shows, and our witness said, that Erlanger should, that the doctor who had previously been sued and Erlanger should have ordered certain tests.
Well, understand that, but that's different. I think that's different. What is the direct negligent claim against the hospital, against Erlanger?
Okay. First thing is, and keep in mind Limbaugh against Coffee Medical Center. That was an opinion by Justice Barker, which held that direct liability on the part of a city-county hospital. Erlanger had people working in the emergency room who had no license. They cannot escape liability. They owe duties to the patients that are coming in who don't pick their physician. They get the physicians assigned to them. In this case, they actually, even though one of them is called doctor, that physician had no license to practice medicine, and neither did the medical student. And they are the two people that worked on the plaintiff.
Did you submit any expert proof that that was a violation of the hospital standards of care to have individuals with their credentials or lack of credentials?
No, that was not necessarily alleged in the, it was alleged that they were guilty of negligence, those
I
two people.
understand that your allegation was that the doctors were guilty of negligence.
Actually, we didn't, at the very beginning, we didn't know who they were. We didn't know whether they were, we didn't find out to the depositions exactly who they were. And that was well past the statute of limitations. And it's our contention that they have to furnish, under the law, they have to furnish medical care in the emergency room consistent with the standard of care for the emergency room. And the proof shows that they didn't do that. And therefore, directly, they are liable. And that gets, and I don't want to say gets around the governmental tort liability, but it's certainly under Limbaugh and under Gilreath even, it indicates that there can be a direct claim against the hospital which would not be covered under governmental immunity.
You use your time, Mr. Berke. Thank you. Of course, thanks to counsel for both sides. We appreciate your briefs and your oral arguments today. Have a good drive back to Chattanooga.